Hey yo, welcome back.
Well, isn't this a nice surprise?
Hey yo, peace fam. Welcome back, let's get to it. So today we're taking on a massive topic, the fight for justice in the digital age. We're gonna break down this new merger between the courtroom and social media and how our perception of the truth is being shaped in real time. This is a journey through a new era of vigilance, and we have 13 points to prove it. We'll start off with the OG OJ viral trial of the OJ Simpson. Then we'll move to the modern court of public opinion in the YSL case. From there, we'll expose a lie in the ASAP Rocky vs. ASAP Relli case. We'll break down the mechanisms of influence and explore the real world consequences for everyone involved. Then we'll tap into some of the recent headlines of YNW Melly and the Unraveling Prosecution, and the nuanced verdict of P. Diddy. We'll talk about the finality of justice with the XXX Tentacion case, and how the mastermind, or so-called, walks free, cleared of all charges of the young Dolph murder trial. We'll cover some recent events such as the KSOO trial and the fight against frivolous claims with Cardi B. And we'll end with the marathon of justice for Nipsey Hussle in a new age era of vigilance. This is a story about truth, family, so let's dive in.
Ain't your money.
Well, the strategy was to fill it with urban music. I don't think
This is a story about truth, family, so let's dive in.
Ain't your money.
Well, the strategy was to fill it with urban music. I don't think a record company can really be successful without urban music, the roots of our music. And we had Death Row. I bought Def Jam. We acquired Cash Money. And just with those three companies, we probably had 45% of all the urban music in America. That was it. And then all the cool kids wanted to come with us. So it was really fun.
So, I mean, it's interesting hearing that because it strikes me that you must have thought about a particular culture, about generating a particular culture at an organization like Universal. Can you talk us through what culture you tried to bring in?
Well, by culture, for me, getting that urban music was cultural, but I had my own culture about how I ran these companies and have continued to do this through my whole career. You end up with an empty slate and an empty disc. I never saw anyone distribute some music that people didn't like. Actually, the only thing that's changed in the industry is the way we distribute music and the way we sell music.
Did you know that 70% of people admit their perception of a public figure is influenced by social media? Now picture that power unleashed inside a courtroom. But today, the topic is not about how social media corrupts justice, but how it's becoming a powerful force in exposing lies and demanding truth. It's bringing a flashlight into the dark corners of the courtroom, holding everyone accountable. As you scroll through your feed, you see a headline about a major case and instantly form an opinion. But what if that opinion is based on the truth because the world saw the real evidence for themselves instead of what y'all been hiding? We're tapping into the chilling reality that is now harder than ever to get away with, a false prosecution because what? The public is watching. Part 1, the OG OJ viral trial. Back when hashtags was a pound sign and way before TikTok clips, we had a new kind of media power. Back in the 90s, the OJ Simpson trial was the first to become a 24/7 media circus. The whole country was glued to their television watching the courtroom drama unfold live on cable news. The case wasn't just about a murder, it was literally a cultural event. The trial was so heavily saturated in the media that people's opinions were often shaped by what they saw on TV, not just the evidence presented in court. It showed us what could happen when a trial becomes entertainment. Long before social media perfected the craft, it set the stage for everything that came after.
Mrs. Robinson. Superior Court of California, County of Los Angeles, in the matter of the people of the state of California versus Orenthal James Simpson, case number BA097211. We, the jury, in the above entitled action, find the defendant, Orenthal James Simpson, not guilty of the crime of murder in violation of Penal Code Section 187A, a felony upon Nicole Brown Simpson, a human being, as charged in count 1 of the information. Superior Court of the State of California, County of Los Angeles, in the matter of the people of the State of California versus Orenthal James Simpson. We, the jury, in the above entitled action, find the defendant, Orenthal James Simpson, not guilty of the crime of murder in violation of Penal Code Section 187.
Boy, you know they was mad when they saw that. You remember that not guilty verdict? Man, they was going crazy behind that. What up, though? I see y'all. Appreciate all y'all being here. Allie, I see you. Brown Sugar Babe, I see you. Trakisha, I see you. Watch the Rise. What up, though? Appreciate y'all joining. Yeah, that was a crazy one back then. That was a crazy one. Let's keep it rolling.
7A, a felony upon Ronald Lyle Goldman, a human being, as charged in count 2 of the information. We, the jury, in the above entitled action, further find a special circumstance that the defendant, Orenthal James Simpson, has in this case been convicted of at least one crime of murder of the first degree and one or more crimes of murder of the first or second degree to be not true. Signed this second day of October 1995, Juror 230. Ladies and gentlemen of the jury, is this your verdict? So say you one, so say you all.
All right, counsel, Mr. Simpson, would you be seated, please? Let's have it quiet in the courtroom, please. All right, Mrs. Robertson, would you please poll the jurors?
Juror number 6 as to count 2, is this your verdict? Juror number 7 as to count 2, is this your verdict? Juror number 8 as to count 2, is this your verdict? Juror number 9 as to count 2, is this your verdict? Juror number 10 as to count 2, is this your verdict? Juror number 11 as to count 2, is this your verdict? Juror number 12 as to count 2, is this your verdict?
All right, the clerk is directed to record the verdicts as read. The parties agree to waive reading of the verdicts as recorded. Mr. Cochran, do you waive reading of the verdicts as recorded? Ms. Clark, thank you. All right, ladies and gentlemen, I want to at this time take this opportunity to publicly thank you for the service that you've given to us, the burdens that we've placed upon.
So this was the OG OJ viral trial. This was like one of the first trials that went viral way back in the day, man. Everybody and their mama was watching this case back in '95.
On you were enormous, and words can't begin to express the debt that we owe to you for the time and patience and exertion that you've given to us during the course of this case.
That's crazy. He made it through there.
That era was the beginning.
And shout out to Chan My Black is Golden and Indigo Kepera. What up? I see y'all. Appreciate y'all joining, family.
Of trials as a primetime spectacle. It showed us the power of widespread media access, how a single moment could define a case in the public mind.
I was thinking last night about this case and their theory and how it didn't make any sense and how it didn't fit and how something was wrong. It occurred to me how they were going to come here and stand up here and tell you how O.J. Simpson was going to disguise himself. He was going to put on a knit cap and some dark clothes, and he was going to get in his white Bronco and this recognizable person and go over and kill his wife. That's what they want you to believe. That's how silly their argument is. And I said to myself, maybe I can demonstrate this graphically. Let me show you something. This is a knit cap. I'm going to put this knit cap on. And you've been seeing me for a year. If I put this knit cap on, who am I? I'm still Johnny Cochran with a knit cap. And if you look at O.J. Simpson over there, and he has a rather large head, O.J. Simpson in a knit cap from 2 blocks away is still O.J. Simpson. It's no disguise. It's no disguise. It makes no sense. It doesn't fit. If it doesn't fit, you must acquit. It reminded me that there was testimony early on that Detective Lang had refused basically to pick up a knit cap inside the Brown residence. It was shown to him, I think, by some of the lawyers and one of the investigators on that date, because he's a fairly common. But they don't really disguise anybody who's noticeable, do they?
If it doesn't fit, you must acquit.
Man, that was a viral line in itself. That was like a meme before memes. What up, Lady L? I see you. Appreciate you joining, family.
We ask him to straighten his fingers and extend them into the glove as one room might put glove on. Yeah, I object to this statement by counsel.
All right, he appears to have pulled the gloves on, counsel. All right, would you show that to the jury, Mr. Simpson, in that manner? Thank you. Other hand, please. He is doing both.
We ask him to grasp an object.
All right, Mr. Simpson. All right. Thank you, counsel.
Thank you.
They said the glove don't fit. You must have quit.
I'm not release you of cross-contamination, Your Honor. I have nothing further.
All right. Mr. Cochran.
I'm sorry, can we approach one moment before we... I want you to remember.
Attorney was like, "Can you pull the gloves on? Can you tighten them up? Can you pull them? Can you put it back on? Put the glove back on. Show the jury again." He was trying his hardest to get that glove on there, or make him change the way he was putting it on there. I'll say
These words, like the defining moment in this trial, the day Mr. Darden asked Mr. Simpson to try on those gloves, and the gloves didn't fit. Remember these words. If it doesn't fit, you must acquit. I was thinking.
Now, after OJ, we didn't see too many big cases. That is until the YSL Young Thug Rico trial. Part 2, the modern court of public opinion.
I know my end fell off. Don't worry about it.
It could. I don't know. I gotta look at the phone page. How do you look at the phone page too? You gotta be specific.
Sure. Would the two of you go out?
I go out with anybody, even you.
I'm not asking about me. For Echo Hotel and what's it for Echo?
You bet. If he said I said it, I said it. Yeah.
Did he ever threaten you to give a name?
Nah, but he kept asking me to make me say a name, and like how you keep asking me a question, I'm gonna say something to answer you, so you can stop asking me the same question. Why would I lie to convince them to not go to jail?
Right.
But they don't know that I'm lying.
Well, they didn't let you go immediately, did they?
Sometimes they let me go.
Right.
But when the time they let me go, I thought I was smarter than them.
Did the detective say that they had to fact check what you said before they let you go?
Can you say it again?
Sure. Did the detectives tell you that they had to fact check what you were telling them?
And you know, in some situations.
Right. And so what benefit would it be to lie if they told you that they had to fact check it?
Oh, it wasn't no benefit, because what they did was they picked and choose where they wanted to take from me, and they still left me in jail, so they came back and beat me in the butt.
Okay. You're not the only one, or you can't see it, why can't you?
So we all seen this, and this is one of the one that brought us all together, this YSL trial. And we definitely seen how our attention played a role in the courtroom as far as Miss Love's looks at the camera and her attitudes after the next days after everybody was talking about her. They was definitely paying attention to all that stuff. What up, though, Joni 4? I see you. Appreciate you joining, family.
Oh, sir. Oh, sir.
Why can't you recognize?
What you mean?
Do you not see? What do you mean when you say you don't know?
I can't recognize the picture.
Do you see yourself in that picture?
No. I told you already, I don't remember. You keep asking me.
So if you don't remember, just say you do not remember. Your Honor, I'll ask.
I'll sustain the question. I'll sustain the
Your Honor, I'll ask. You can instruct Mr. Copeland if he does not remember, just to say he does not remember.
Mr. Copeland, just answer the question to the best of your ability, okay?
I thought I did, Judge.
You're.
I told her I don't remember no conversation I had with. She trying to cross me up. She trying to say this and that. When I don't told her I don't tell the police anything they wanted to hear for them to, and she keep asking me over and over.
You're gonna have to answer the question, sir, okay?
About how old were you all when you took this picture?
I don't know.
Do you have hair on your head when you take the picture?
What you
I took the picture.
The absence of evidence is not the evidence of absence.
What?
Volume down. Hey, shout out to Chan, my black is golden. Appreciate the $2. She said the iconic clips. That's a fact. Appreciate that, family. Y'all show us some love. Drop some coins and some witch emojis in the chat. Starting off the stream sponsorship. Appreciate you, family.
I don't know.
Do you have hair on your head when you take the picture?
What you
I took the picture.
It look like I got hair on my head.
How long ago have you been bald?
I got a prison.
Okay. So this is before you went into prison.
This is an old picture.
And that's what I need to know. Thank you very much. Do you need to sit down?
Nah, I can like it. I ain't had nothing to drink.
Do you want some water?
You gonna give me a drink?
I'll get some water.
I don't drink water.
Wow.
Well, I'm trying to tell you.
Do you remember or do you not remember something?
What I'm trying to tell you is our conversation was about something that I said in the past.
I understand. I'm asking you.
Ask that Mr. Copeland allowed to finish his.
Okay, all right.
I'll tell you what's up.
Mr. Copeland, you need to finish your answers?
No, I need a break now.
Say again?
I need a break.
If Murphy cooperated with the DA's office, the office would cooperate with him. Routine in such cases. Hudson says he acknowledges before Walter Murphy, who surrendered on the YSL racketeering conspiracy indictment.
Look, I'm surprised attorney ain't holding his hand. Get your hand out my pocket. Y'all remember this attorney. This the one who had his hand on his back and his knees and all that.
Went to prison in 2016.
I did my time like a man.
He was a bad dude.
He was messed up in 2012 and 13 and 15, but he has since changed.
The purpose of count one is to hold the defendants responsible collectively.
The YSL Rico conspiracy count alleges acts by Murphy, including an aggravated assault with a deadly weapon on or about September 11, 2013, an attempted murder involving 4 different victims on or about April 12, 2015. Hudson says Murphy had been charged in those incidents years ago, and he pled guilty or guilty in what's known as an Alfred plea, basically to reduce charges, and until his surrender had been out on parole since early this year. We spoke to Murphy when he was free.
I spent 7 years in prison. While I was in prison, I stayed out the way, and I just got my GED, completed all my classes, completed the transition center. I transitioned back into the world. I got me a job at the transition center.
A prosecutor says a victim in one of the incidents in Murphy's past lost part of his head in the shooting. Hudson says Murphy was present, not the trigger man, in the shooting of a man who lost part of his head.
He has an extensive criminal history.
Defense lawyer Hudson acknowledges the pleas he worked out to Murphy's earlier cases, one negotiated and one non-negotiated, were sweet deals. But he maintains Murphy made the most of them. And since his release is not associated with YSL and has held a steady job.
Changed his tone and changed his life.
But these days, that media circus is decentralized and is happening all over your phones. Take the YSL trial, for example. The infamous Young Thug YSL Rico trial. The core of the prosecution's case has been, in their own words, rap lyrics and social media posts. The DA argued, Fannie Willis that is, that posts and song lyrics were evidence of a street gang. But online, the narrative was different. Fans and artists like Drake and others showed massive public support for Young Thug, fighting against the idea that his lyrics were Drake. That his lyrics were a confession and not just art. That battle of hearts and minds was playing out online in real time as the public was finally able to get another glimpse inside this thing they call the courtroom. You see how quickly art can be twisted into evidence and how public support fights against it? The narrative isn't just about what's said in court, it's about what goes viral. This push and pull between the legal and digital courtroom makes every high-profile case a battle for perception. Just like what we saw with A$AP Rocky. Well, I mean, kinda. Part 3, a lie exposed.
No one in the building. What's good, family? I see you. Appreciate you joining. Time for part 3, a lie exposed. Let's keep it rolling, family.
He kind of jumped when he shot. He kind of shot down. Like, you know what I'm saying?
The gun that he was holding, did it look like the same gun that he pulled on you at the parking lot?
Yeah.
And when you say he shot down, what do you mean by that?
Like, I mean, like it was kind of like this. It wasn't like pointing at you, but it wasn't like aiming at you. It was kind of like that. So he, like I said, it was like a movie kind of like boom, and then like just running around trying to like get me.
Okay, the motion he made with his arm, Your Honor.
That's right.
Yeah, so he had his arm extended out, and then as he was saying shot down, he lifted his arm up to about head high, and then had his pointer finger sort of pointed forward, but in a downward trajectory.
Yeah, it was higher than this. Well, I don't really remember, but from what it was more like.
Now, look at the case with ASAP Rocky, aka Rakeem Mayers. The details are intense. He was accused of shooting at his former childhood friend, Terrell Efron, aka ASAP Relli, aka Relli Jelly, aka Scrapey Knuckle Note, aka OG Knuckle Scrapes, OG ASAP Knuckle Scrapes. So Rocky was facing 2 charges of felony assault and a possible 24 years in prison, family. But this case became a masterclass in social media transparency. The whole world was watching the trial unfold during the cross-examination of ASAP Relli Jelly. The defense presented evidence that contradicted the story of ASAP Relli. And from what we seen on the stand, we didn't have much to disagree. We literally watched the prosecution fall apart because the truth was being exposed for everyone to see. After nearly a month-long trial, the jury found ASAP Rocky not guilty of all charges. The verdict was a win for the defense, it was a win for the public that refused to believe a lie, and it was a win for Rihanna, who we also happened to see in the courtroom that day. Now, this case showed us that sometimes, despite all the noise, we are not too dumb to recognize when the math ain't mathing. We know how to say 1 + 1 = 2. So why would you lie to the people?
Also at 12:04 a.m., you sent a text to John claiming that Rocky shot at you, right?
I mean, I'll have to see the thing where your songs were.
And again, that stipulation still stands, right, guys?
Well, why don't you just stipulate, tell the jury what you're stipulating to?
The time of 12:04 on November 7, 2021. Same text, right?
4 minutes after that, but the problem is if you're asking him what he remembers, we'll stipulate to him.
Right.
Then if you then ask him afterwards, doesn't know the
Right, you don't know the exact time, obviously, that you sent the message, right?
It was 3 years ago.
I understand. I'm saying you don't know the exact time. Right, okay. But we have a stipulation agreement that you sent it at 12:04 a.m. You sent him a text claiming that Rocky shot at you, correct?
And so stipulated.
All right. And then you sent subsequently, 4 minutes later, you sent John a screenshot of your scraped fingers. Remember sending John that?
Yeah.
Okay. And at that same time,
Big Joe Taco, Taco Peanut. What up, though? My bad, yeah.
time, again, guys, 12:38 a.m. that same day. You sent John a message saying, "I'm getting itch." You remember that message?
Yeah, I'm getting itch. It was a typo.
Okay, all right. The message that you wrote to John was, "I'm getting itch, ITCH," right?
I don't really recall, but I think
we can show it to you. That's John's.
Daniel Berry Sports Highlights. What up, family? I see you. Appreciate you joining.
We will draw that last question. What did you mean when you said I'm getting itch?
Well, when I was talking to his manager?
Yes, sir.
Well, I was just showing his manager everything, and I think he took a while to get me back, so I said, I think that's what I wrote, but in the translate, that's what I meant to write was I'm getting irritated. But then you said, I'm getting rich, and that's when me and you started arguing at the preliminary hearing. Like you was trying to get something out of me, something more out of me.
So you meant the right word, irritated?
When I first spoke to his manager, I don't remember what I wrote, but from what is there, yeah.
Well, you saw the word itch, right? You saw that message.
I mean, but you flipped it so many times. That was a fast moment. You can't make me go back and think like something that I don't really. I definitely won't write his manager in the context. If you show the whole text message, where would it make sense? I'm getting rich.
All right.
You're not showing the whole text message.
So, You saw these messages yesterday. You wrote that.
I mean, if we want to pull up John's text messages, we can.
Okay, thank you, sir. So what you're saying to this jury is that you didn't mean to write that you were getting rich, right?
I don't recall.
Okay. You're not saying that you didn't mean to
I don't recall, sir.
Just don't recall. Okay. So you may have been meaning you're right to get rich.
I don't recall. Okay. If I said anything like that, I mean, not said anything. Anything I said after the shooting was lawsuit. It falls in my lawsuit. So
what?
It falls in my lawsuit. Like a crime was committed. And
He said it falls in my lawsuit. Anything about that, it falls in my lawsuit. Dude, wow. What up, Rock Solid TV? I see you. Appreciate you joining, family. Y'all go sub up to Rock Solid.
then whatever I say after that's pertaining money or anything that's compensating me was with my lawyers or anything else. I had lawyers present and everything else.
Well, you didn't have a lawyer at this point, did you?
When I spoke to John, I didn't need a lawyer. What I need a lawyer for if I didn't say I'm getting rich? And what does getting rich have to do with a man shooting me?
That case also showed us that when the world is watching, people are less likely to get away with lies. But what are the hidden mechanics behind that influence? Part 4, the mechanisms of influence. This isn't just a bunch of people sharing their thoughts. It's like a calculated dance between algorithms and human psychology that is now being used for good or bad, depending on your perception. Algorithmic amplification. Social media platforms are designed to promote highly engaging content. And what's more engaging than justice and truth? The algorithm doesn't really care about truth or context, but when millions of people are watching, liking, and sharing clips that expose a lie, the algorithm amplifies that truth. Decontextualization. The worst part used to be that a 10-second clip of a 5-hour testimony could be taken out of context. In a world where everyone's watching, someone will always find the full video and expose the lie, changing the public's perception back to the truth.
Is pointer finger sort of pointed forward, but in a downward trajectory.
Well, I don't really remember, but from what it was more like, it was fast. He turned around, and then it was like, boom. You know what I mean? Like, yeah. Not like that.
Okay. You said that as he shot the gun the first time, you said your hand felt hot, correct?
Yeah.
Where on your hand felt hot?
My left hand.
Where?
Left hand. Just right above my knuckles. Like my knuckles right here, below my knuckles. So it's right here. And if I was to fall, you would see other injuries on that picture from that day from my knuckles and all around here. That's why. You know what I'm saying? Like,
okay, yeah. I just have to, when you point this out, I have to describe it.
So my knuckles,
what he's
I
pointing
still
to
got a mark from that day.
What he's pointing to are the middle knuckles on his left hand. Kind of, he has his hand toward
The online mob. Social media also creates a powerful group think. It becomes a mob mentality, but instead of harassing, they're working together to find evidence, exposing inconsistencies and demanding accountability. Now, this collective energy is like a shining light on the darkest parts of the legal system. Although this groupthink can also be used vice versa to destroy instead of rebuild.
How it even got this far?
You know,
do you feel like it was plain hatred?
I mean, on their end, I feel like even if it was the nigga Big Jook, for example, right? Yo Godz name ain't came up in this shit none, right? His label CMG shit coming up, but what I'm saying, they didn't say Yo Godz put the $100,000 hit, and y'all motherfuckers know Yo Godz got a lot of fucking money. They saying Big Jook did this, right? Yo Godz know the hustle. Yo Godz knew from him, Dixon, 3 6 Mafia, and all the rest of these niggas how to hustle and make money. So even if it was Dolph, if it was internet beef or if it was about beef or whatever, money came from this shit. Just remember, people bought into this shit. Don't play with me, play with your bitch. That motherfucker's on stream. Like me personally, if I thought I was dealing with a real gangster, I wouldn't even be bothering that nigga on the internet. If I'm bothering a nigga on the internet, I don't feel like that nigga a gangster. I'm playing with that nigga because I don't think that nigga no gangster. Real gangsters don't fuck with gangsters. You smell what I mean? That shit automatically bondage. If you're a killer, I'm a killer. We know each other, man. I just don't think that it was no real super goddamn killer animosity between the nigga Dolph, to my brother Dolph and the nigga Yo Gotti. That's my personal opinion. You know, I think that both of them hustled and made them a whole lot of fucking money, and then you got this old douchebag ass nigga Juke wanting to take the extra mile.
You see, it's a perfect storm. The way these platforms are built, combined with human nature, creates an environment where narratives can be weaponized for justice. And when that happens, the consequences are very real, far beyond just likes and shares. And part 5, the real world consequences. This isn't just about a public image. It has real consequences. Jurors, even if they're instructed not to, can be influenced by what they see and hear online. But now that influence can be a force of good. A person can be acquitted in the court of law, and their name can be cleared in the court of public opinion, according to what we see and visualize with our own eyes and our own opinion based on the evidence shown. This is a challenge to the very foundation of our justice system. And if it's something we all need to be vigilant about, the next time you see a viral clip or trending hashtag about a trial, ask yourself, am I watching the evidence or am I being shown a narrative? Part 6, the unraveling prosecution. As we know, the legal system can feel like a fortress, but recent developments in the YNW Melly case are showing that even the strongest walls can crack. The first trial ended in a mistrial, but a recent appeal has exposed even more of what appears to be a pattern of prosecutorial misconduct. The defense is arguing the prosecution's own actions tainted the case, and now the judges are taking a close look at the details. This is a critical moment. It's not just about the evidence itself anymore. It's about whether the prosecution played by the rules. This appeal shines a light on the prosecutorial misconduct style of going after a defendant, a dark space where the truth can get lost in the state's pursuit of a conviction. And now the public is demanding that if justice is going to be served, it has to be served correctly and fairly.
So I appreciate y'all being here. We about halfway through. It's not a long one tonight. I did crash my my talker, so I gotta fix that. So we gonna just tap into this full little hearing. I haven't even watched it yet anyway. I wasn't here while I was recording it, so I do want to see it. And we gonna get into that, and then after that we should be out of here. So we about halfway done. Appreciate y'all being here. Don't forget to hit that like, hit that subscribe, tap in, share with a friend. Appreciate the love, family.
No.
You pick
No.
No, he's sleeping.
Well, isn't this a nice surprise?
The Fourth Amendment's protections, a defendant must establish standing, showing that he has a legitimate expectation of privacy in the area to be searched or item seized. And at his first trial, the defendant disavowed ownership of the phone, which included the iCloud accounts, social media, sort of those attendant sources. And the lower court, which had presided over the first trial in these proceedings, agreed that the defendant had, quote, was basically saying it wasn't his phone. And so, despite never having affirmatively claimed ownership, the trial court here found that because he disavowed it once, but didn't disavow it again, that was tantamount to claiming ownership and a privacy interest in the phone. That's simply not what the law requires. So in this case, the defendant never made that initial showing of establishing ownership and his expectation of privacy. And so that's sufficient for this court to reverse the grant of the suppression motions on that basis alone.
Did he take the stand at trial and testify that that wasn't his phone?
That was just the theory, was that the state had not proved that the phone and the social media accounts were.
It was the position that the lawyer took in the first, the different lawyers, of course, but right? What didn't he get?
I don't know if it was the same or a different counsel. I'm not sure. I don't know.
That's what they said, the lawyer said in the first. Okay.
That was their theory. It's not his phone. You haven't proved it's his phone. So certainly he didn't claim ownership of the phone to establish standing. And the same here. He never claimed ownership of the phone. And the court, instead of saying, you've shown, your ownership interest, your privacy interest, said, well, you haven't not shown. So that was the crux of the error, basically. And so as to independent source, the purpose of that exception is to leave the police, the state investigators in the same position, but not a worse position, if there had been no error with the warrant at all. So here there are several independent sources, which left investigators with all the same puzzle pieces that they would have had, even if the court, years after the execution of most of these warrants, wouldn't have found that it needed to have a narrower temporal scope. So not that the warrants themselves were bad, but that the time period was too broad. So the strongest, and there's several, and I'm not going to recount my briefs as the court has reviewed them, but the strongest sources were the victim Anthony Williams' phone, which contained not only the cell site evidence, which showed that they were traveling together and then weren't at the same time that Mr. Damon's phone was moving in the same way, but showed the communications between them that were ultimately suppressed when they suppressed the iCloud results that showed that they were longtime friends, that they were having...
The absence of evidence is not the evidence of absence.
What?
Yo, big shout out to Joni Ford. Y'all show her some love, drop her some coins in the chat and some Blue Jays. She do got her own emoji here. Y'all show her some love. Appreciate the support, family. Appreciate the gifted membership, as always. And what up, Shay? I see you. Appreciate you joining, family.
Dispute over money, over the direction of their rap group collective. Those same messages would have been found and were found independent of Mr. Damon's phone. The same with public social media posts regarding gang activity, regarding...
one of the problems that it would seem to me the state has on here is that it really relied on Detective Polo's testimony to develop the independent source, inevitable discovery issues. And Detective Polo came into this case at least 4 years after the shootings. And with the benefit of 20/20 hindsight was going back and sort of looking at it. And it seems to me he was saying what he would have done had he been on the case. But, couldn't the judge reject, or don't we have to assume that the judge rejected Detective Polo's recreation of that in deciding that inevitable discovery and independent source were not appropriate? He could have rejected Polo's testimony because it was after the fact and wasn't even involved in the case at the time.
Independent source specifically looks at either before or after the initial search at issue. So it just has to be independent. And Polo came on board, I believe, when the superseding indictment was filed, which added the gang enhancement. And so it now became even more relevant to get this information, the gang-related information. And when we look at what he looked at, everything that he looked at was available or would have been available to Relli when he did his first 13 warrants, the ones that are at issue here. So he's looking at publicly available social media posts. He's looking at those communications in the phone extractions that we already have from either the co-defendant or the victim's phones, and looking within Moretti's, applying the temporal restriction that the judge imposed. From there, was able to get all the same information. So independent source is not defeated by the fact that his investigation came after, merely that it's independent. And it obviously was independent, right? Because he's looking at a slightly different angle, because he is concerned and his expertise is the gang involvement. And he's also involved in the tampering case, looking at what he was doing in terms of tampering with witnesses. So the fact that we have those independent sources and that Polo is independent of Moretti, I would say helps the state's case. And the case law is clear that the independent source can come after as long as it's independent.
You use the word would. He would have had that information available to him. But isn't that easy to say in hindsight? And how do you distinguish between every case in which, sure, in hindsight, vision is 20/20. Mm-hmm. So look.
Y'all remember Polo now. We just recently showed him not too long ago with his mask on his... he was on the stand with the Pooh Shiesty. The mask on his face.
Looking back on it, Detective Moretti can say, sure, I would have done this, and I would have done that. But what framework are you suggesting for, if this were to apply to every warrant, if the state were to always say, well, we would have found it through an independent source, now knowing what we know?
Oh, and what up, though, Miss D56? I see you. Appreciate you joining, family. Look, there go the Pooh Shiesty on the screen. He got there go, what's the detective? What's his name, Moretto?
Why don't you look back to what they did then?
Polo,
they
Detective
actually did
Polo. Polo.
Or would have done without having the benefit of hindsight. See what I'm saying? What framework do you suggest for every warrant?
Well, and I think in this case, it's crucial that the investigators had all of these pieces already. So they already knew that this was potentially a gang-involved shooting, that Mr. Damon specifically was involved in a specific gang that they named. So they do have all of these pieces, and the warrants that they were traveling under included these communications at in this time. So he did not obtain those warrants because he didn't need them, because he thought he already had the material from these warrants. And we can absolutely see a world in which you can say, well, I would have done this, and that's not allowed. But here we have very specific testimony where Detective Polo goes piece by piece. This, for example, the Facebook post with the defendant and his co-defendant, and they are wearing shirts that commemorate the victim's death, and they're talking about the victims. That specifically, he says, that would have led me to believe reasonably that they are having communications on Facebook about these murders, and then that would have led me to seek a warrant for these murders. So I think in this case we have a lot of specificity. I'm sure the court is aware that the hearings with Detective Polo were quite long and quite involved. So it was more than mere, yeah, we would have done this, we would have done that if we didn't know. These were the investigations he was already doing before the motions to suppress were filed. And I think some of the cases talk about that. When are these independent sources coming up? Is it before or after a motion to suppress is filed and you're scrambling to kind of find something else? That's not the case here. These investigations were ongoing. He was already pursuing these materials that were publicly available, so therefore an independent source, and already in the state's possession, like the victim's phone, the co-defendant's phone. So there is no sort of benefit to anyone to exclude the things the state already had. And I think that distinguishes this case from others where maybe they don't have that, or they go out to seek it after a motion to suppress has been filed. Any more questions?
Not at this time. Do you want to save it 5 minutes?
Yes, thank you.
Sounds good.
Have to chop and screw it real quick.
Good morning, Your Honors. Carrie Howlett on behalf of Jamel Demons.
How do you feel about standing? How do you respond to this?
Well, I find it so curious that issue is even raised. Because if we look at the record of the hearing in front of the trial judge, which is why the trial judge did not even address standing, the state specifically said, at one point, I do raise the issue of standing. I'm withdrawing that argument. That was based on misapprehension of the ownership of the devices, and that's just in 10 and 11. And that is on R3347. So I would submit that the trial court did not address standing because the state specifically withdrew that argument in the trial court. And it would be very difficult now to recreate the facts for standing, not for standing in front of all of you. So I would submit the state has waived that argument, not even waived it, withdrawn it in the trial court. And so it's not an issue. As also argued in the briefs, the affidavits themselves establish standing, as they all allege that the phones are Jamel Demons, the various social media accounts are Jamel Demons. So I would submit that the affidavits also support standing. I think this case really presents sort of the classic modern day.
The evidence is not the evidence. The absence.
What?
Yo, shout out to Allie, member for 8 months. Appreciate you, family. Y'all show us some love. Drop some what up, send some smoke emojis and some Allie emojis. Type Allie or some coins or whatever you want to do. Show us some love. Appreciate you, family.
Fourth Amendment concerns from 1789, right? Where the concern of the government being able to rummage through a person's most personal information and most extensive, frankly, more extensive than what you might be able to have in a home back in the 1700s, has to be limited. It has to be limited by a warrant. It has to be limited by a warrant that has probable cause to believe there's a crime, and that particularly describes what is to be searched. Probable cause to find a gun doesn't allow law enforcement to look at a diary just because it may be interesting to know what does the suspect think, do, know, what are their activities, and that's really what most of these affidavits support. In terms of leaving to the unfettered discretion of law enforcement, the affidavits themselves really lay out that that's what we're asking for. We'll decide what's irrelevant. We want all of this information. We'll go through it and decide if there is information that supports our investigation. So while we do take issue with the trial court's adoption of the severability doctrine, which I'll spend a minute or two at the end talking about, you have to respect the painstaking efforts this trial judge took to consider the lengthy written arguments, read the 13 affidavits and warrants, and listen to 2 days of evidence initially, write an extensive order, the omnibus order, addressing each warrant individually. And they all have different time frames and different matters the trial judge went through specifically to address. What information was sought, what was obtained, and what did the affidavit support? So the trial judge considered the individual circumstances and the probable cause, and then the trial judge allowed essentially a relitigation of issues with inevitable discovery and independent source that should have been raised initially. It is why Judge Murphy's order comes to you with a presumption of correctness as to the determination of the facts. There's quite a bit of argument in the brief as to the appropriateness of even having the reconsideration hearing that litigated the only issues the state is now arguing, independent source and inevitable discovery. I leave to the court that issue, as you're the purveyors of the rules of procedure, but it appears the state's argument really primarily was raised under the guise of the motion for rehearing and reconsideration, as these doctrines were not even raised initially. So apparently the government accepts the court's ruling regarding the overbreadth of the warrants and relies on independent source and inevitable discovery. The trial judge did not find much value in the independent source, and it appears that the state's argument is that not that the evidence, which is all of the evidence that was subpoenaed, right, all of the phone records, all of the social media, not that that evidence would have been independent, that there was an independent source for, but that there was an independent source for another warrant for those items. And I would submit that is not the purpose of the independent source doctrine, that the purpose of the independent source doctrine is really, I think maybe this court in Carter addressed it, where the evidence of I think it was Carter, the tag, yes, there was evidence obtained from a driver's license, but the tag was totally independent from the driver's license, and that evidence was obtained at the same time and was used to connect the suspect to the crimes. So independent source, the trial judge found the state was sort of conflating the two. I will admit the case law is at times sort of mixed. I believe what the U.S. Supreme Court has said is that inevitable discovery is sort of a part of independent source. But essentially the government argues that Polo's investigation 4 years later into gang activity would have uncovered the same information if he had obtained a warrant supported by probable cause and with particularity. Since that was never done, we don't know if that would have occurred. But essentially the government argues that Polo's investigation 4 years later into gang activity would have uncovered the same information if he had obtained a warrant supported by probable cause and with particularity. Since that was never done, we don't know if that would have occurred.
Aren't most of the independent source cases and inevitable discovery cases, don't they, it seems to me that they involve like the police officer goes and runs into a house on exigent circumstances, but the police are already in the process of getting the warrant. So the warrant, that whole process is in place, and the judge, it's easy to look at it and say that, oh yeah, they would have found that. Isn't this kind of a unique application of that?
I would say yes, it is a very unique application. What we do know from the cases that address, and as I say, some of it is interchangeable, but independent, inevitable discovery,
I'm seeing a lot of 13s on the screen, so I might as well go on and show some love to Chan My Black is Golden and Watch the Rise. 13 months of membership. Hey, that's over a year of consistency. Appreciate that. Much love to you for the love. Y'all show them some love. Drop them some coins in the chat. Drop her Chan My Black is Golden, some witch emojis. Appreciate the support, family. Much love.
Rodriguez, that there has to be a showing that that investigation was already underway. So the warrant they were already going for, even though there was an illegal entry into the home, and the warrant was obtained without any of the information from the illegal entry. And, the Supreme Court in Rodriguez, this court in Roll, has always said you have to show that the investigation was being actively pursued at the time. So what we have is Polo's investigation 4 years later, not actively being pursued at the same time that Moretti is pursuing the warrants and obtaining all of the information that he did. So I think it's very distinguishable. It also is, so I was thinking about this. It's the retrospective analysis. Detective Polo didn't just look at the publicly available information to come up with his opinions.
Did y'all hear that? 4 years later. 4 years later, he want to come and try to prosecute and start like he doing a whole new case, like he doing something. And still in the ski mask though, 4 years later. Like, who even know who you is? Like he a gang member. Seen him throwing up the gang. Let me pull his picture up while she talking.
Already reviewed, and this is in the record, all of the data that had been obtained pursuant to the warrants that the trial court had then ultimately ruled had to be temporarily limited. He then went back to the information and superimposed the temporal limits that the court ruled on, and then said based on those temporal limits and all, oh, I could have done this or I would have done this. It's so much speculation, it's so much hindsight, and frankly, it's, you know, and I don't mean to impugn Detective Polo in any way, but we have to assume he put out of his mind all of the illegally obtained information that he already had reviewed. And I just don't think the courts are expected to do that, especially with an investigation 4 years later on a separate topic. And what the trial court was concerned about is that Polo's investigation was really about the gang enhancement that is alleged in the 2023 charges. And Detective Polo says even he would have limited his warrants to information related to the gang investigation. So then we have two separate things that we're even investigating, and what evidence would have been relevant to the homicide versus the gang investigation. I think this is why the courts do say you have to show you're actively pursuing the same information at the same time as you obtain it unlawfully. And I think that the trial court really...
Which Polo do you prefer? Which Polo would you be more cooler with? Let me start a poll in the chat. Who's the best Polo?
You know, patiently listened to another day of testimony from Detective Polo. Overruled for purposes of the hearing, repeated objections to speculation, right? Because Detective Polo routinely said, well, I woulda or I coulda or shoulda. And the defense objected to speculation. Trial judge said, yes, it's speculation, but I'll allow it for this hearing. But in conclusion, he ruled it was all speculation, that Detective Polo's testimony was based solely on speculation that he would have done these things. We might be in a different posture had there actually been, at the same time, warrants issued for the gang investigation, and we could compare, was there an independent source? Would it have been inevitably discovered? But instead, we're going 4 years later and looking back on it.
So I need to move you along. Let me just have you address, one other thing.
Yes.
So we get off this. I don't need to interrupt you, but the didn't the trial court save the state's bacon by narrowing the temporal application of the
yes
of the thing? And why you need to address why that's not why that was error or
okay.
why we shouldn't do
and
that.
thank you for I'm not so good with clocks. So the temporal severability issue is a novel issue in Florida. The trial court cited a footnote in an older case. Severability has been used in other contexts like legislative enactments, things of that nature. But in terms of in Florida on warrants, it has not been used. And I would submit for policy reasons, right? Because it really would encourage law enforcement to just go get everything and then let the trial court make the decision. Well, now we know this is relevant or this part is appropriate, rather than once it's found to be overbroad, the entire warrant should fail. And so I would submit that is a novel issue in Florida. The federal courts have addressed it and have addressed it in various ways and with various limitations. And I finally note the trial court did note on the severability issue that you should weigh how much information was obtained lawfully within his, the time limits that were imposed versus unlawfully. And there's really nothing in the record that tells us what that is, but I would point to specifically.
But here's, let me, in doing that analysis, let me just interrupt you. He's, what he wanted the warrant for was to pin down the location of the defendant. And so it seems to me that in the drop of all the evidence, that all the location testimony is going to be, that's relevant is around the time of the shooting. And the stuff that goes back to, I don't know, October 1st, or that's really not relevant to the location at the time of the shooting. So in weighing the testimony, why couldn't the trial judge have decided that this was the relevant evidence, this is what they were looking for, and that that this serves the proper purpose?
So I would have a hard time disagreeing with you if it was just the day of or the day after, but there are a number of these warrants that stretch, and the trial court ends up allowing for a couple of months. And I would submit that those, I know on the motion to suppress number 11, which might be Gmail's, I have to look at my notes, the court said the vast amount of data obtained compared to what would be relevant. But there's really is not, appropriate. But then he does limit it, but to like a 2 or 3 month period. And I would submit that there should have been a specific weighing. Was there much more data gathered illegally than what was important for and supported by probable cause? That's the standard that has been accepted by several of the federal courts and that the trial court cited. But that analysis is not contained.
See, my last question, I get that, I understand your answer. My last question is this. Look, you talked about the policy that, would be implicit with this. And this is a quote from, I had to read.
Yo, shout out to Jakesha. Y'all show us some love. Have a good night, family. Appreciate you stopping by. This is just part 1. We'll have part 2 coming soon. Y'all show us some love in the chat. Drop us some green hearts and some coins. Appreciate the love, family.
The absence of evidence is not the evidence of absence.
What?
all these federal cases to prepare for this because there's not much in Florida. But the Fourth Circuit in U.S. versus Relii of Velez said that courts, this is a quote, courts should not punish law enforcement officers who are on the frontiers of new technology simply because they are at the beginning of a learning curve and have not yet been apprised of the preferences of courts on novel questions. I mean, doesn't that make sense to you that we should be more forgiving of courts and law enforcement at the beginning of this frontier, which really starts with California versus Riley versus California when this applies to cell phone, and now we're in the area of social media.
So yes, except I would say by 2018, there were some cases with regards to this, and some of the later warrants weren't until, I think, 2020. So, you know, we should learn and we should grow. And I think law enforcement, given their enormous power, should be charged with the responsibility of keeping up with some of those areas of law. My time is up. Thank you very much.
Yo, Joni4. So if you go to, like, you about to donate, like if you go to the $, like you about to donate, there should be a selection down there that says milestone or membership milestone, and it'll let you know how long you've been a member, and you could for free every month you get one free chat to post how long you've been a member. So if you go click the $, it should be the last selection that says membership milestone or something like that, and it should be no charge to post that comment. And to tell you how many months.
Let's move away from standing, okay, to really the heart of the case, if you mind. I mean, that's really, I think, what I'd like to focus on. Look, in the Supreme Court in 1920s decided Olmstead versus the United States, which applied to a wiretap off-site of bootleggers who were operating a business in a townhouse, and then we come up years and years later, and we're now in social media and cell phones in Riley versus California. And the problem that I'm having with these warrants is that they were so broad. I mean, that I was surprised that the trial judges signed these warrants for the timeframes when they were really trying to get the location. And it seems to me that law enforcement needs to take the bull by the horns initially and narrow the search, because that's the way search and seizure law is developed up until this moment in time. And in this case, why didn't the trial court save the state's bacon, as I asked Ms. Howitt, by narrowing the temporal time of the warrants? Because these warrants were, there's no way a month before any of the information would have helped their initial detective locate the defendant at the time at or around the shooting. I mean, you just can't make that argument.
Well, I think when we look at what...
Here they go again. I think when you look at why don't you, look, this is the appeals court. The judge is telling you can't make that argument, but they still sit here and try to come with this bullshit. That's why I think that should be prosecutorial misconduct, because there's no reason for y'all to keep on doing this. Got you, Joni4. You see it? Let me know if you see it.
Especially those initial warrants, what Murray is looking at. So it's not only his location.
Oh, yeah,
it's location, and then they get...
Joni4 for 10 months. Damn, 10 months, and you just now knowing about that. My bad. I should start telling people. You could have did that 10 times. Shout out to Joni4 for the 10 months. Y'all show us some love. Appreciate you, family. Drop some of them Blue Jays in the chat. Show us some love. 10 months. That's what's up. Appreciate it.
It's not the evidence. The absence.
What?
There's a progression in the warrant applications. And first it's, well, this vehicle has shown up and people are dead. What's going on? And so this is all you know. So you're like, okay, well, let's look at the phones of the people in the car, their locations. And then you get to location, you get to Mr. Damon's phone, and then you see that he is communicating constantly from lead up to the murders, to the execution of the murders, and thereafter. And those...
But why shouldn't courts require law enforcement to start narrowly, around the time, use information that it obtains to go back and get warrants later that broaden the scope of what the law enforcement is allowed to search?
Well, I think when you read the warrants together, I do think that's what's happened here. We started small, and then with more information, it's like, okay, now we have cell site information, so we know where you were. And then we find Mr. Withers, for example, who's talking to Mr. Damon's on Snapchat, and we know he's communicating through Snapchat.
Yeah, but the initial evidence drop, was huge. I mean, and didn't the first detective have to go through hundreds of thousands of pages of data, like to really find out what was relevant?
Right, and I think that's the nature of the way they receive this evidence. So another thing that we haven't addressed, but another job of the state is to identify the owner of the accounts, the phone. And you need, I think they call it, I don't know if proof of life is the right turn of phrase, but so you need some space outside. We're not talking about a year before. This is like 3 weeks before the crime. And the phone itself, the iCloud account, only existed since August. So this is really a case where you cannot possibly say, well, we're going to get your entire life forever and ever.
But the point, if I understand Judge Gross's question correctly, is even
3 weeks was arbitrary in the trial judge's determination that there was no relationship provided as to why the 3 weeks point was just, well, let's just go back a certain amount of time. And there's no probable cause for that.
And I think that's where it was to establish the identity and the owner of the phone. I believe that was the basis that Moretti, and I remember Polo also said that, but I believe that's what Moretti testified to. And so you also have the officer testified, I also believe it was Moretti, that the way they receive this, it's not sorted for you by, let's say, Apple, and you say, well, only give me this evidence of the crime. They just don't have the capacity to do that.
But couldn't law enforcement be required, let's say with Apple, for example, they've got some pretty smart people working at Apple. Couldn't they give them certain language parameters, like certain keywords, and have them, I don't know, I don't do this, but have them conduct a search in that way, subject matter, narrow the parameter of the search? Because there's temporal, but
couldn't they do a keyword search? Have you ever heard that? He said, I know, I don't do this, I don't know much about it, but I'm pretty sure you can do a keyword search. Shout out to Allie with the 5 gifted memberships. Appreciate you, family.
What?
Show her some love for dropping the 5 gifted. Appreciate you. I was trying to catch it so I could pin it to the screen, but this thing be scrolling so fast, and the way it's set up, it just ain't working right now. But I'm gonna get it together. As a matter of fact, I can pin this one. Here we go. I'll pin this comment for you right here. Appreciate it. Y'all show Allie some love for the 5 gifted memberships. If you got gifted a membership, show her some love. Appreciate you. Let's keep it rolling.
if they gave it to Apple, couldn't Apple search according to those language parameters?
The testimony was that they could not, that they didn't have the capacity to
But that
sort.
came from the cop. That came from the
and there's nothing to contradict that,
well, I mean,
right?
it would be different if it were somebody from Apple. I mean, right?
And the defendant certainly had the opportunity to present that argument or evidence, but the only evidence we have, the uncontroverted evidence we have from the testimony of Relli is that it cannot be sorted in this way.
Couldn't the judge kind of assume that we generally all know now that cell phones track your location. I mean, that didn't need to be proved. And I mean, wouldn't it be similarly
I don't think so.
assumed that that Apple could track could conduct a search based on narrower search parameters set up by law enforcement?
I don't believe it's the same. We don't use that technology the same way we use, if I have Google on my phone and I'm using Google Maps to navigate to the courthouse, I understand that information is saved in Google. I have no idea how Apple, and I'm not very techie, so maybe that's why, but I have no idea how Apple stores, keeps, sorts, tags their information. And so I don't think that that's within the common knowledge of, a judge issuing a warrant. It is within our common knowledge. I think most of us use the GPS on our phone now, so I think that's within the common knowledge, but I wouldn't say how a software company keeps and tags its information would be commensurate with that.
But going forward, don't you think that, like that quote from Zalaev Esweza, those are the types of things that law enforcement should become cognizant of in obtaining warrants?
I don't know
because when you do a wire, just a wiretap from the old school stuff. I mean, there were very narrow parameters that were allowed in the wire. You couldn't listen to every call.
Right.
The concern here is that the police are looking at everything that's dropped on the cell phone.
And I think in the wiretap, the police are in control of when they're listening and how they're listening. The police are not in control of how Apple keeps its records and how they
But they
provide
didn't
them.
try, right? He didn't try. It's not that Apple told him no. It's that Apple can't do it. But there was no evidence that they requested either a temporal limitation or search terms, and Apple turned them down. And I think the point is that as we move forward, why aren't these things that law enforcement should be trying while trying to balance the Fourth Amendment protections? And I'm left wondering why they needed the entirety of these social media accounts to identify the owner or proof of life, as you said. I mean, that could be very narrowly tailored. In fact, they said they were going to have a taint team. So the detective clearly knew that this was fairly broad and he was asking for a lot. So he recognized that we're going to have a taint team, but then that never happened. They just got access to everything and went through everything and decided what was going to be relevant and what wasn't. So how do you justify searching the entirety of somebody's social media account for something as narrow as identity?
Well, and I think we have to go back with what we have in this record, and it was the Moretti's testimony that in his experience, they don't have the capacity to sort, and so we have nothing to say that they do, right? So I think there's just no way to do anything other than take that as this experienced officer's experience in.
What up, Aubrey? Y'all? YSL Polo, bless him hard. I see you. Appreciate you joining, family.
Obtaining warrants. And in terms of the social media accounts, they were tailored because I think the focus was communications. What are you posting about? What are you commenting on? And who are you talking to? Because we have probable cause to believe that you're having conversations about not only committing the murders, so the premeditated design to commit the murders, the accomplishing of the committing murders, and then covering up the murders after the fact. So in this case, it's not just a broad, well, who is it? It's like we know, and the warrants go through, this is the specific trail I'm following, and and I have probable cause to believe that they're having these communications on these platforms with this person and what they're talking about. And so I don't have the same reading that it's this broad anything and everything you've ever posted on social media or anything you've ever said on social media. It was focused. The earliest was October 1st, was like the earliest date that was requested, which is a few weeks before the murder. And like I said, I think in this case, the independent source is so strong because we have complete untainted communications sitting there in these devices that were not obtained through these warrants that Mr. James would have no standing to contest, and they contain the same information that is the definition of an independent source. And so there is just no benefit to anyone, to society or investigators, to suppress when the evidence is literally sitting in the exact same phones that are already in police custody. Can I just very quickly make the point about the standing, that the withdrawal as to the standing, consent standing was only as to suppression 10, which is the physical device of the phone, and that's because there was confusion with the whatever the number of the phone was. But you can see in the motions for reconsideration, specifically standing was contested on all the relevant motions that we are contesting. So with that, we ask that you reverse. Thank you, Your Honor.
Okay, thank you, folks. We'll take this under advisement. Counsel, very well argued by both sides.
And when it happened, Melly and Kristen had Instagram pages. He went on his page. They went on his page.
Shout out to everybody in the chat. Appreciate y'all being here. Shout out to everybody who's showing the support. Ali says, since we come to show out tonight, we gotta share the membership love. That's what's up. That's what's up. Appreciate that, family. So this right here is the victim, one of the victim's dad. I forget which one it is, but it's one of the victim's dad that was shot in the car with YNW Melly, allegedly. So we're gonna play a little bit of that. Then we almost up out of here. Definitely appreciate the love and support, family. Let me scoot this a little bit down so it's not in the way. Appreciate y'all. Miss D says she's saying a whole lot of nothing. That's a fact. Ended it just in time. Let's keep it rolling.
Whoever took all the pictures down of Chris and Anthony and made it look like they was never existed. If he's so innocent, they never put up a reward to his page. Whoever.
Counsel, very well argued by both sides.
And when it happened, Melly and Kristen had Instagram pages. He went on his page. They went on his page. Whoever took all the pictures down of Chris and Anthony and made it look like they was never existed. If he's so innocent, they never put up a reward to find the killer. They never did a tribute. They never did anything. They even pushed Chris' funeral back from 11 a.m. to 2 p.m. just so Melly could make it, and he still didn't show up. And he never showed up at the Sack funeral. So this your best friend, and you don't even come to the funeral? That just, I don't know, man. That guy deserves everything coming his way. And I have no sympathy for him. Him or nobody in his family.
Well, Chris Thomas Sr., thank you.
60 years to life in prison. This coming here on.
This is just a sample of part 2 that's coming up. I was going to make this a full long one, but I had some technical difficulties, so we're going to cut it a little short. But I still got a couple more clips, so it ain't over yet. But this is a sample of something was coming up, and I want to know which full trial y'all want to see me cover out of all these, because we could go back and cover the full trial in one of them at a time.
This Wednesday out of Los Angeles. Of course, this is a live look in the courtroom right now. The Superior Court judge handed out the sentence to Eric R. Holder, who was found guilty of the 2019 first-degree murder of the 33-year-old Grammy-nominated hip-hop artist outside the clothing store Hussle, founded in South Los Angeles, the neighborhood where both men grew up under very similar circumstances. It was a month-long trial. The jurors in July also convicted Holder of 2 counts of attempted voluntary manslaughter, 2 counts of assault with a firearm for gunfire that hit 2 other men at the scene who survived. They sentenced Holder to 25 years to life for the murder, 25 more for the firearm sentencing enhancement, and 10 for assault with a firearm. Of course, the loss of Nipsey Hussle hit the hip-hop community very, very hard. A lot of great renditions from him as an artist there. This is a live look in there.
Next, Your Honor, is Mr. Herman Douglas.
Mr. Douglas? Herman Douglas, H-E-R-M-A-N, Douglas, D-O-U-G-L-A-S. I work for Nipsey. Nipsey, my friend. He was like a son. He was like a dad. Our community right now, we lost everything. Everything we worked for, one person took that person out of our community. Thousands of jobs we don't have no more. Homies don't have nothing to do. They backsliding. They robbing people now. We had stuff to do. Now they don't have nothing to do. All our stores are closed down. We were relying on jobs. The whole community relied on them and the team that we had down there. Now the team is not down there. Nip is not down there. The whole community is affected. All of our stores are closed. We have nowhere to go. We can't go to Rouse to get no food. The only thing that we have is that shopping center. That shopping center is closed down now. Tourists are coming by there, can't even take pictures no more. Everything we built got torn down. One man's mistake, one man's action messed up a whole community. Our whole community is suffering to this day. These kids don't have nowhere to go. They have nothing to do. They have nothing to look up to no more. And the world still wants to know why. We want to know why would somebody do that to a person that was leading the whole community. Why? We want to know why. That's all we want to know is why. We will possess a person to take a person out of our community that was so powerful. So many people depended on that person. Nobody depended on this other person. Everybody depended on this one person in our communities. And they want mercy from this guy. Where was the mercy when he was kicking Nipsey on the ground? Where was that mercy at? Where was that mercy at? You want some mercy? You want somebody to show you some love? You ain't even looked at nobody. You didn't even look at the jury and show no respect, no remorse. Sir. To say, my bad, I messed up. You know, sir, I got you. I'm trying to do it the right way. Thank you, sir. All right. But there's been no remorse from the individual that's on trial. So I'm asking you, Judge, it really, you know, the time, I don't care what you get a guy. It ain't about the time. I need to know why. I wish I could get that. You know, his fate is sealed. He took a man's life, his life is getting taken. Simple as that. You know, it goes against the body. So his life has been forfeited. So he has to kill the guy. You know.
To thank the members.
Let's go back to Robert Allen. He's the man I just told you about who pleaded guilty to second-degree murder and is testifying for the state. On Wednesday, Allen took the stand and claimed that he and the three defendants robbed and killed XXX in the parking lot of the motorcycle dealership. He explained what happened over those 3 short minutes.
Trayvon Newsom do after he grabs the bag.
As he grabbed the bag, shots were fired.
Judge, I'm going to ask him to speak to the microphone.
As he grabbed the bag, shots are fired.
Who shoots the shots that are fired?
Michael Boatwright.
And who does he shoot?
Triple X.
Where does he shoot him from? What side of the car?
Driver.
So if Triple X is in the driver's seat and Michael Boatwright is in the driver's side, the shots are coming onto Triple X's left side or right side? Which side?
Left side.
Okay. And what happens, how many times do you...
So if you don't know, as she just said it, this is from the Triple X Tentacion murder. They got a lot of that, so we could cover that one if y'all interested. Let me know.
Recall that Michael Boatwright shoots Triple X?
Maybe like 2 or 3 times.
What does Triple X do as a result of that? What does Michael Boatwright do next? What does Trayvon Newsom do?
Comes out, slips and falls a little bit and runs the car.
What does Dietrich Williams do? Now, are all 4 back in the Dodge journey?
Yes.
What does Dietrich Williams do?
He drives off.
So yeah, y'all let me know. This right here is some footage from that trial. Also, this is the shooters on camera. For those who haven't seen it before, they did show that in court. They have all the footage. That's them when they first came in and all that. But let me send my shout outs. Shout out to Aubrey Ya. I see you. Appreciate you joining, family. Much love to Aubrey Ya. Appreciate you tapping in with us. Shout out to Miss D56. David hasn't happened yet, has it? It don't gotta be necessarily court stuff. I just mean any of those that you just want to see me cover. It ain't gotta be the full trial, but I'll do a little video or something about it, depending on which one y'all pick. Shout out to Joni Ford, stream sponsor. Appreciate you, family. Y'all show some love to Joni Ford. Shout out to No One. Appreciate you being here. Much love, much love. Chad My Black is Golden, stream sponsor. Y'all show some love to Chad My Black is Golden. Drop her some witch emojis in the chat. Shout out to Allie. Much love, much love. Drop her some what up, what up, what ups in the chat. Watch the rise in the building. Joni Ford, let me see. Daniel Berry Sports Highlights. Much love, much love. She was gifted the membership. Rock Solid TV, what up? I see you, appreciate you. Trakisha rolled out, but Trakisha was up in here, appreciate you. Y'all show some love to Trakisha. Allie in the building. Brown Sugar Babe, I see you, appreciate you being here. Shay, appreciate you being here. What up, what up? The Pooh Shiesties. Chan Black is golden. All right, that looked like about it on that side. Let me see. Send some shout out to our stream sponsors.
The absence of evidence is not the evidence.
What?
The absence of evidence is not the evidence of absence. Y'all go sub up to Rock Solid TV and No One. Shout out to the stream sponsors. Watch the Rise, Joni Ford, Trakisha, Chan Black is golden, and Allie. Appreciate y'all being here and showing love and support. Y'all show them some love, drop them some more coins in the chat before we roll out. Appreciate all that. Like I said, it's gonna be a short one tonight, but I got some more coming soon. I got some more stuff in the works. This one just got cut a little short because I was having some technical difficulties. I gotta fix my avatar, so you know what that means. Next time I come back, I might have a new look. Usually when I gotta fix it, that means it's time to change it. Let me see. Before we get up out of here, let me hit y'all with a bonus. What's this? Oh, that's a little deep. Let me see.
Office of Police Accountability is investigating a body camera video captured in January of this year, the day a 23-year-old woman was hit and killed by a Seattle police officer. The officer, who has not been charged with a crime, was responding to an emergency call and was in a 25-mile-per-hour zone when he hit and killed Jannavi Kandula. Kandula had the right-of-way in the crosswalk when she was hit by the cruiser going approximately 63 miles per hour. Well, tonight, Seattle police released a video from another officer reacting to that crash the same night. And we want to warn you, some of the description is graphic.
I think she went up on the hood, hit the windshield, then when he hit the brakes, flew off the car. But she is dead.
Description is graphic.
I think she went up on the hood, hit the windshield, then when he hit the brakes, flew off the car. But she is dead. No, it's a regular person. Yeah. Yeah, just write a check. Just, yeah, $11,000. She was 26 anyway. She had limited value.
The Office of Police Accountability is investigating a body camera video captured in January of this year, the day a 23-year-old woman was hit and killed by a Seattle police officer. The officer...
The driver pulled over for speeding, pointed a rifle at a highway patrol officer yesterday. CHP says it happened just north of Redding on I-5. An officer stopped a vehicle on the Mountain Gate off-ramp. The driver, they say, got out of the car, pointed the AR-style assault rifle toward the officer. Officials say the suspect re-entered his vehicle and then they started pursuit. Vehicle continued southbound, driving at varying speeds before exiting the freeway at Oasis, continuing for about 2 miles west before stopping near Vigil Court.
I guess he wasn't scared of him with that big AK, huh? He wasn't scared enough to shoot. We out, family. Much love. Stay fresh. Stay blessed. Peace out.
Kids will not be. It ain't your money. I will be fine. Our kids will not be.
ain't your money.